Estate tax changes under the 2010 Tax Relief Act. Estate planning is about much more than just the estate tax. However, over the last decade, it's changes in the estate tax that have made estate planning so challenging. As a result of 2001 legislation, the top estate tax rate was slowly reduced from its 2001 level of 55% to 45% in 2009. At the same time, the estate tax exemption increased from $675,000 in 2001 to $3.5 million in 2009. Then, in 2010, we had the year of the estate tax repeal. With no estate tax, a few wealthy individuals seemed to get a free pass, leaving billions of dollars to their heirs estate tax-free. But 2010 was also a year of uncertainty. The estate tax was scheduled to return in 2011 with a top rate of 55% and an exemption of $1 million. And there was some expectation that the tax would be retroactively reinstated for 2010. What happened? At the 11th hour, Congress gave us the 2010 Tax Relief Act, a 2-year Band-Aid. The new law includes several important changes. The estate tax is reinstated for 2010, but estates can opt out and be subject to the carryover basis rules that were previously in effect for 2010. Property in estates that do not opt out will receive a step up or a step down in basis. The top gift and estate tax rate is 35%. And the estate tax exemption amount is set at $5 million. Also, for 2011 and 2012, the estate tax exemption is portable between married spouses. That means that when one spouse dies, any unused portion of that spouse's estate tax exemption amount may be transferred to his or her surviving spouse. Finally, these rules sunset or expire on December 31, 2012. Unless Congress enacts further legislation, on January 1, 2013, the estate tax is again scheduled to be imposed at the top rate of 55% and with an exemption of $1 million without portability. What will happen beyond 2012? No one knows for sure. But it may be wise to review your current estate plan and revise it if necessary. For example, plans using a formula tied to the estate tax exemption should recalculate. Spouses, children, and charities may now be getting too much or too little. Credit shelter trusts may no longer be needed. Instead, a disclaimer trust and/or powers of appointment may be more useful to allow a surviving spouse to decide if and how to fund trusts at the death of the first spouse. Further, planning for state death taxes with smaller exemptions may now play a more important role. Plans need flexibility, now more than ever. If you have concerns about your estate plan, don't hesitate to ask questions and get expert help.